call. Gilitaceko?
Here.
Matt Ferguson?
Here.
Suzanne Sikora Ludwig?
Here.
Christella Tella?
Here.
Ivan Adorno?
Here.
Diana Lopez?
Here.
Bob Kartika?
Here.
George Shadid? Manuel Castaneda? Okay. Oh, 1, 2, 3, 4, 5, 6, 7. We have 7. As chair nor vice chair are in attendance. Ms. Sikora Ludwig, you'll be chairing the meeting.
Yep, I'm sorry. I was not prepared for that. Let me see if I have to pull up the agenda. Just give me a second, please.
It's all right. I think Manny may be having some technical trouble. He was supposed to be here.
Okay, let me just find, I just need to find the agenda, Dan. I'm sorry.
No worries. No worries.
Nope. Good grief. I'm almost there. Hold on. Okay. 1 second. Just bear with me. Okay, I'm here. Can you do the public announcement, please?
Yes, ma'am. Let's see. Please be advised that the notice requirements of the Open Public Meeting Act have been complied with and satisfied, and that the annual notice, which gave sufficient notice of the time, place, and conduct of all public meetings of the Planning Board of the City of New Brunswick, has been filed with the City Clerk and has been placed on an appropriate bulletin board and posted in the back vestibule of City Hall, visible to the public through the windows in the lobby of City Hall, New Brunswick, New Jersey, and has been transmitted to the official newspaper for the City of New Brunswick, namely the Home News Tribune and Star Ledger. The City Planning Board intends to meet on a regular schedule and meet the guidelines of the Open Public Meeting Act by utilizing teleconferencing and video systems. Public participation at public meetings has been revised, and the public may participate through a conference call-in system. The public is encouraged to call into the call-in lines through the phone numbers and access codes transmitted in the above notice to the Home News Tribune and Star Ledger and posted in the back vestibule of City Hall, visible to the public through the windows. During public comment periods, I will first read public comments issued to the board, then those on the call-in lines who have interest in addressing the board will be first organized by last name and called upon to speak. All organized members of the public will have an opportunity to speak once and for no more than 5 minutes in any given public meeting portion. A timer will chime at the completion of each 5-minute period, and I'll notify you that your time has expired. Public needing assistance accessing the call-in number should call the planning department at 732-745-5050.
Thank you. Please join us for a salute to the flag. I pledge allegiance
to the
to
flag
the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible,
individual,
Liberty
and justice for all.
And now, members of the board, you should have received the minutes for the last meeting. If there are no changes or corrections, can I have a motion to approve?
I'll move to approve.
I'll second. Christel Tell, second.
Sorry, I thought it wasn't muted. I missed who motioned initially.
I did, Bob Carter.
All right, thank you, Bob. Arvin, is there any action for you to take, or we can just proceed to vote?
This is for the minutes.
Oh, I thought this was the other thing. Okay.
this is the-
Right, because right. I'm just missing. I have my voting sheet mixed up. All right, no worries. Okay, so.
Dan, it's Manny. I'm here. I apologize. I'm having some internet access issues, but I think I'm okay now.
Okay. Noted. Arvind, would Mr. Castaneda take over as chair for the meeting at this point, or?
He should at this point take over as chair. Mr. Castaneda, what's before the board currently is the adoption of the meeting minutes from the October meeting, I believe. Is that correct?
Yes.
There was a
Yeah,
motion.
so just a roll call.
Great, thank you.
All right. So Yelitsa Checo.
Wasn't here last meeting.
Okay. All right, there we go. Suzanne Sikora Ludwig.
Yeah.
Christella Tella.
Yes.
Ivan Adorno.
Yes.
Diana Lopez.
Yes.
Bob Cardica.
Yes.
Manuel Castaneda.
Yes.
All right, thank you.
Dan, I was present for the last meeting, but you didn't call on me for the vote.
I'm sorry, Matt.
But
Would
I
you like?
vote to approve the minutes.
Thank you, Matt. I'm sorry about that. All right, so that's all right. We can continue.
All right, moving forward to section 5, resolutions of memorialization. We have A, New Brunswick Auto Spa LLC, 1200 Somerset Street, block 597.01, lot 1.02, PB 2021-01.
Chris Delatelle like to make a motion to.
Mr. Chairman, this is Dan Klein, attorney for the objector to application 2021-01. I just wanted to go on the record regarding the reconsideration issue prior to the board's adoption of the resolution.
Mr. Chairman, if I may.
Yes, go ahead, Mr. Idle.
Thank you. We received 2 correspondence which have been provided to the board members, and I believe they've both been posted online from Mr. Simon. 2 letters dated, first letter dated October the 7th, second letter dated October the 8th. And I've confirmed with the board secretary that this was part of the packet that was distributed to all board members. So all board members having reviewed that, let me just summarize what the objector, Mr. Simon and Mr. Klein, who just popped up on the screen a little while ago, requesting essentially are 2 things. One is that the resolution not be adopted this evening. And second, that the board reconsider the prior decision to approve the application and to permit the objector to cross-examine and put on its witnesses. Actually, its witness, Mr. Simonoff, who is made known to the board in the letters as their professional engineer and professional planner, and that they would notice the public as well. As indicated on the adoption of, or the approval of the application, the board has 3 avenues it can take. The first is the board on motion may grant Mr. Simon's request. The second is that the board may choose not to adopt the resolution in its current form, make any changes to the resolution if the proposed resolution is not in any way accurate. And finally, the board can adopt the resolution on motion. I understand there is a motion. I will state for the record that there was a correction to the resolution of approval, which the board members got in their packet, and they should also have the corrected resolution. And just to put on the record as well, page 2 of the corrected resolution, the 5th whereas in the resolution itself, which would appear as the 3rd whereas paragraph on page 2, the words "and received" in that 3rd whereas are deleted. There was a motion, Mr. Chair, so I think it would be proper to see if there's a second on that motion first.
I did.
Yes.
I made a second. I seconded the motion.
And this is for a motion, I'm assuming, to adopt the resolution with the deleted words "and received" from the 5th whereas. Is that correct, Mr. Stellatella?
Yes, that is correct.
Right, and and the second is with that stipulation, correct?
Yes.
All right, we have a motion on the floor.
All right. Suzanne Sikora Ludwig,
Yes.
Christella Tella,
Yes.
Ivan Adorno,
Yes.
Diana Lopez,
Yes.
Bob Cardica,
Yes.
Manuel Castaneda.
Yes. Motion carries. We then move to section 6, other matters of interest to the public. A, miscellaneous amendments to Title 17 zoning ordinance. Dan?
Yeah. Hi. Thank you for not skipping over. So good evening, everyone, and give me a second to put on my my camera, and I think Mr. Ital will have to swear me in.
I will.
And,
Mr. Dominguez, when you're ready, if you could raise your right hand. You swear or affirm the testimony you're about to give this board shall be the truth, the whole truth, and nothing but the truth.
I do.
Mr. Chairman, the witness is sworn.
Thank you. Go ahead, Mr. Dominguez.
Thank you, Mr. Chair. Today, before the planning board, I have the city has a
Mr. Dominguez, I'm sorry.
slew. Yes.
If you could just tell us who you are for the record.
I apologize. Where's my thing? There it is. I'm trying to. Technology. Right there it is. All right. Hi. My name is Dan Dominguez. I am the planning director for the city, and tonight I'm presenting a slate of miscellaneous zoning amendments to the city zoning ordinance. So once again, thank you for having me tonight. I'll go through them individually. These are largely minor amendments, and I expect to potentially field some questions from the board as after we go through them, or if any member of the board wishes to interject midway through. I have no aversion to that if there's any questions that pop up. So beginning first, there are some proposed changes to definitions in the zoning code, particularly with regard to gasoline stations. This summer, the state of New Jersey adopted an electric vehicle statute bill that supersedes and preempts a lot of local municipal electric vehicle standards, which the city adopted either in 2019 or 2020. I don't remember when, but we in the somewhat recent past adopted our own standards, which are now superseded by the state. One of the changes was that the state law would allow any gas station use to also be able to double as a permitted use as a electric vehicle charging facility, essentially equating the two. What Section 1 and Section 2 of the ordinance, as you probably you should have received, the changes: one deleting the gasoline filling stations and one adding new definitions, would change gasoline stations to fueling stations, but not just encompassing the what was added by the state law, but also with a bit of a forward-thinking mind to any other legal fuels that can be used for vehicles. As some car companies are advancing hydrogen fuel cell technology and the like. This so goes a step further or two than the state law to allow that any gas station would be able to also convert not only into an electric vehicle charging facility, but also a hydrogen facility, or a mix and match of all of them if they want, which may end up being the case. It's hard to predict the future. Going on from there, and in a similar sort of forward thinking vein, we would be looking to exempt rooftop solar panels from zoning review. Right now, it's basically a rubber stamp permit. It comes in, we get a fee, we look at it. It's solar on the roof. Yep, here you go. Here's your permit, and then they go and they get construction permits. But the zoning, while it's not basically a rubber stamp, it also does add, in some cases, anywhere from 1 month to, I've seen it as long as 3 months of a delay of things hitting the construction permit stage. This would add a very de minimis cost to the city in the situation of not getting somewhere between $500 to $1,000 a year in total application fees from these small permits. Would expedite the rollout of a rooftop solar citywide, hopefully. Beyond that, a couple of changes regarding permitted modifications to height in particular. So these two are regarding residential and commercial building height. The existing zoning code has a piece that allows for deviation from front yard setbacks when the neighboring properties don't conform to the code and they're closer than what's in the permitted code. You can sort of split the difference between your two next door neighbors. So let's say it's 10 feet, but your two neighbors are, one of them says 0 and one of them's, let's say, 8 feet. You can build your building up to that 4 feet without it being a variance. So this sort of takes it a similar approach, factoring in neighborhood context to building heights, but without granting too much over flexibility from the zoning code. For residential building heights, if the two parcels, the two houses that are on each side of the parcel in question that has a proposal, and those have, let's say, it's a zone that allows 30 feet high, and those both are above 30 feet, then they could either go to the middle property can either go to the average. So let's say it's 31 feet and 33 feet, they can go to 32 feet. But if those two buildings were 40 feet and 40 feet, the limitation would not be able to exceed 10 feet or greater than 10% of the height permitted in the zone. So they would be able to go up to 30, in this case, 33 feet, as that would hit the 10% threshold. The idea here is to not grant too much of a waiver administratively, so that anything beyond that still requires board relief for a variance, but also to accommodate neighborhood context, as some neighborhoods will just have taller buildings than others, even if it's like slightly de minimisly so. And similarly with the commercial building height, thinking of commercial corridors, so we would affect in a similar way the 10 feet or 10% of height permitted in the zone. But in this case, rather than just the properties on side by side, we would factor in the entire block frontage. So if 50% of the block frontage is above the zone, and they would be able to go up to the average of those properties, or up to 10% or 10 feet, whichever is lower. So it's similar to the residential one, but with more of a holistic and universal approach with the block frontages. Continuing beyond that, outdoor mechanical equipment. The amendment here would allow for outdoor HVAC equipment that has a decibel rating at or below 40 decibels to be up to 5 feet away from the nearest property line. Currently, all outdoor mechanicals must be at least 10 feet from any property line because they can be very loud, and particularly a lot of HVAC condensers can be quite loud. But there are options that can go at or below 40 decibels, usually mini splits and the like, and they are often 4 to 8 times quieter than conventional HVAC systems. So this would allow for greater proximity to property lines, which is a great flexibility considering how many parcels in the city are limited in parcel width, as they're many of them are 25 by 100 old parcels that wouldn't be able to readily fit a 10-foot setback for just about any backyard equipment. Continuing forward, looking at roof treatments, this would create a requirement that what roofs that are determined to be considered flat roofs would either have to have a white roof, green roof, or have solar panels. Typically, these roofs would probably be white roofs or have solar panels, and it would be exempted to single and two-family homes. If you spend some time and you do a Google Maps aerial of the city, one would notice that a significant portion of the industrial part of town, which is where a lot of this would be taking place, already has a combination actually of both white roofs and solar panels. They have the real estate for the solar panels, so a lot of them roll it out that way. And white thermoplastic paint is often a good sealant for those roofs, so it already gets used quite significantly. Large portions of also the hospitals and the apartment buildings in town also have white roofs or solar panels. So this should not produce any meaningful detriment to any city developments going forward, but will be hopefully a nudge in that direction for anyone taking on any projects. Then we would be looking to adjust the front setbacks in the C2A neighborhood commercial zone. So the C2A zone is it's essentially French Street up to where it meets Somerset Street is basically the C2A zone. And so this is an existing older commercial corridor where the bulk of the buildings are either right on the property line, or a very significant portion of them are actually just probably slightly into the right of way from what I saw on some maps. And the zone currently requires 10 feet, but that's one, largely unrealistic, but two, doesn't really conform with any of the existing development in the corridor. So this would just set it to 0 for front yard setbacks, making no other changes to any other setbacks or other bulk standards in the zone. That way, for homogeneity with the rest of the corridor. Then general provisions Q.4. The zoning code was amended I want to say it was about 17 years ago, to prohibit parking in front of people's houses, like where you can't have a driveway that leads like right up to a window or something. But the language in the zoning code made it so that any parking essentially in front of the house, unless it leads to a garage or carport, would be prohibited, which would mean that a lot of existing buildings that have a driveway that would lead, to the backyard or to a fence, but not to the main house, they just don't lead to any structure, would be captured somewhat accidentally in the framing of that ordinance. So what this change would do is that as long as you're not parking in front of the house, you can either be parking, in front of a garage, in front of a carport, or you can be, leading up to a fence, you can be leading up to the backyard or to a continuous driveway continuing going forward, as long as it's not in front of the house. So this allows for clarity and a sensible modification to make it easier to approve driveways in town while continuing to uphold the spirit of the original amendment to the zoning code way back when. And then lastly, a couple of changes. One that sort of reinforces the changes from the state law and deletes our electric vehicle statute and changes it to the provision of electric vehicle charging infrastructure and parking shall be in accordance with state law, completely deferring it. There is some flexibility for changes for municipalities from state law, but it's quite insignificant. And for the time being, the city has decided to just defer to state law standards on this item. And then lastly, just the deletion of section T, which was a secondary portion of the city's electric vehicle ordinance, which is again based on the prior section, would be completely superseded by the state law. And those are the proposed changes to the city zoning code.
Thank you, Mr. Dominguez. Any questions for Mr. Dominguez from the board?
Dan, it's Bob Carlica.
Hi, Bob.
Just to clarify that the title, the section 7 amendments, those relate to your Front Street front setbacks, correct?
Correct.
Okay, and again, you provide this table in the amendments.
Right.
It's kind of meaningless in terms of what these numbers mean. Could you just kind of explain that again? In terms of
Certainly.
what the implications of that change are?
Sure, not a problem. Let me pull that up once again. Sorry here. All right, so where are we at? Section 7. And for guidance sake, in section 7, the modification is the 1, 2, 3, 4, 5, 6th from the left section. It's where the 0 is. The 0 feet is.
I see.
Right.
Okay.
Yes. So once again, the existing ordinance for the C2A zone lists a required 10-foot front yard setback. The reason for the modification here is that a 10-foot setback in that zone is, one, it's unrealistic. Modern developments that have come through boards will typically are building to the lot line. And the reason is because the entire neighborhood is pretty much built to the lot line. There are very few buildings that have any setbacks at all. And as I stated, many of the buildings in the zone actually encroach into the right-of-way by some a couple of inches. I saw a couple that are about a foot or two into the encroaching into the right-of-way. And so for the sake of simplicity, avoiding unnecessary variances that would be ultimately granted as relief by the board anyway, given neighborhood context, and for homogeneity with the and consistency with the existing built environment, to change it from 10 feet to 0 feet.
Okay, I got it. Thank you.
You're welcome.
Any more questions from the board for Mr. Dominguez? All right, hearing none. So is this call for a motion, correct?
Public comment.
Public comment.
Arvin, can I do it
Yeah.
myself or
Well,
should
let me-
I not?
Yeah, no, I don't think you should, since you are the witness. Mr. Chairman, with your permission, if I may, there are only a few members of the public here, so let me ask if any member of the public in attendance today would like to make any comments or ask any questions regarding the testimony that was just heard. If you can please unmute yourself and identify yourself, and we'll set you up in an orderly fashion to be heard. If there's any member of the public that wishes to be heard.
Charlie Cradaville here. Can you hear me?
We can, Mr. Cradaville, and let me just see if anyone else is there. Is there anyone else besides Mr. Cradaville who would like to be heard? Last chance for anyone who would like to be heard on this application. I'm sorry, on this presentation, or have any questions for Mr. Dominguez. Mr. Chairman, it appears that we only have one individual from the public, Mr. Cradaville. If I could have him sworn in, if he'd like to present any testimony or if he's got any questions Doesn't need to be sworn in, just to make comments.
Yeah, you can proceed, Mr. Cradaville.
Okay, thank you, Mr. Vice Chair. First and only question is, will there be another opportunity to speak on matters of general interest to the board? Or is this the only opportunity I'll get to speak tonight?
No, there'll be another opportunity. This is specific to this.
Okay. Thank you. I just want to say definitely support rooftop solar and anything the city can do to facilitate more buildings, having making use of their roofs in ways that will help combat the climate crisis is a good thing. And that's the extent of my comments on this. Thank you.
Thank you, Mr. Cradaville.
Mr. Chairman, as there are no other members of the public, if you could ask for a motion to close the public portion and then a voice vote.
Yes.
Second.
I can get a motion to close the public comment for this particular amendment request.
I'll move.
Yes, Mr. Kartika
Second,
Yes.
and Mr. Corlett.
Suzanne, second. Yes.
Mr. Chairman, just a voice vote would be fine for those who approve to close.
Okay.
All those in favor?
All those in favor?
Aye.
Aye.
Any opposed?
Hearing none. It passes and we move forward. All right. Continuing with other matters of the interest of the public. So, Dan,
So just to jump in,
Yeah.
for clarity's sake, so that was a motion to close the public comment, or is that a motion to vote on the amendments?
Yeah, so we've closed the public portion, Mr. Chairman. At this point, it would be appropriate for any board discussion or a motion to approve or disapprove the suggested amendment.
great. So I apologize. Thank you. So can I get a motion? Well, are there, either for discussion, to open discussion, or is there a motion to approve or disapprove the amendments?
Just so the board members are aware, this would be a recommendation to council to act on this, since the board itself cannot enact an ordinance. This would be a recommendation to council to approve or disapprove the amended changes.
Thank you for that clarification.
It's Chris Delatella. I'll make a motion to present this to city council to accept the amendment.
Let's check a second.
Thank you.
And we'll need a roll call vote. Dan, I don't have the roll, so I'm going to ask you to put
I'll
on.
do it. Yeah, I'll take off my planner hat and put on my my board secretary hat. Yalitza Checo,
Yes.
Matt Ferguson,
Yes.
Suzanne Sikora Ludwig.
Yes.
Chris Delatella,
Yes.
Ivan Adorno,
Yes.
Diana Lopez,
Yes.
Bob Kartika,
Yes.
Manuel Castaneda.
Yes.
All right, thank you.
Thank you. All right, moving on now to other matters of interest to the public. Dan, if I can get you to do your thing.
Once again, there are very few members of the public present here tonight, so I will open it up generally. If there are any members of the public who wish to address the board under public comment, please announce yourself and I'll put you on a list of speakers. You'll get up to 5 minutes to address the board. If you're on the computer, you have a little microphone button to unmute yourself. If you are on a telephone, please use *6 to unmute yourself and announce yourself. So,
Yes,
is there
Charlie
any member
Cradaville.
of public? All right, Mr. Cradaville. All right. Is there anyone else from the board who wishes? From the public who wishes to address the board tonight? General public comment. Anyone at all? Chairman Castaneda, seeing none.
If we can have Mr. Cradaville, you're up.
Yes, good evening once again, Vice Chair, members of the board. Charles Cradaville. You know me well by now. I'm the editor of New Brunswick Today, a community newspaper here in New Brunswick, available online at newbrunswicktoday.com. I'm also a resident of the 2nd Ward. I live on Saddam Street here, and I have a number of questions and comments to make tonight. The first one I'd like to know, is Mr. Crum still on the board?
My understanding is that Mr. Crum has resigned, is no longer on the board.
Okay. And I'd like to know, there's a new member, I believe, Mr. Adorno is now on the board. Can you tell me who he replaced?
Mr. Dominguez, was there an actual replacement that Mr. Adorno is taking?
Thank you, Vice Chairman Castaneda. Ivan Adorno was appointed as the mayor's representative. He took the place of Ryan Berger, who was the prior mayor's representative on the board.
Okay. And I guess I should ask, have there been any other resignations that we don't know about, or any other changes to the board members in the past month or so?
Mr. Dominguez?
I believe that Mr. Petrolino has also left the board.
Okay, well, that is a shame, because John Petrolino was one of the only members of the board that was willing to actually give a fair hearing to applicants and listen to members of the public. I know he was probably disappointed with how the last meeting went. It's been alluded to before, but the board creates these rules, and then when somebody actually tries to use those rules to object to an application, you don't even follow your own rules. And that's what happened at the last meeting, where, you know, interested party had hired an attorney, waited on the phone for hours to get their chance to cross-examine witnesses and give their presentation, and the board bamboozled them and pushed through the application without giving them the fair hearing they deserved, and that's atrocious. And you had a chance to make some corrective action tonight, but you obviously made another bad decision by not doing that. I'd like to know, I put some work into writing a letter to the board members on October 4th. I got notice very late that you were going to be discussing something on October 4th. I might have found out a day or two in advance. And, I wrote a letter. It was a page and a half. I called your secretary, board secretary, Dan Dominguez, and I, made sure that I could get that in before the meeting so that the board would be able to review it. Mr. Castaneda, you're probably not the best person to ask, because I know you were conflicted on the application and had to recuse. But I know Ms. Sikora Ludwig ran the meeting. Maybe through you, Mr. Vice Chair, could Ms. Sikora Ludwig answer the question, did the board actually receive my letter and review it before making their decision regarding the misrepresented witness in the Devco parking deck hearing?
Mr. Ithal, what would be the procedure here?
Yeah, Mr. Dominguez, I believe if that was in fact that letter was provided to all board members, is that correct?
Mr. Ital, to my recollection, I believe that the letter was received the day of or after the cutoff for the consideration of submission of documents. So it was not provided to the board as part of the consideration for that day.
And what would the cutoff be?
Mr. Dominguez, is it the Wednesday prior to the hearing?
Yes, I believe so, Mr. Ital.
Well, that's interesting, because you accepted a letter from the person who lied to the board and misrepresented a non-architect as an architect. You accepted a letter from him on the Friday before the meeting, and then at the last minute changed your agenda to add this item as an executive session item. I found out, I presented my letter, and my letter was not considered, is what you're telling me. The board was only given one letter making one side of the argument, but not my letter raising the concern?
Do we have a response to this?
I think he's making a comment.
I'm trying to clarify that this is what happened, that there's you made up an arbitrary, just now you said all documents have to be in by Wednesday before the meeting, Well, the other letter came in Friday before the meeting. So how is that the cutoff? Did the board review the letter from Mr. Liebling?
I guess, Mr. Ithal, how would we proceed? Is this a question directly for Mr. Dominguez?
I'm not sure that the board members, at this point, this is public portion for
Right.
comment. I appreciate Mr. Cradiville has a number of questions that he'd like to ask, but I don't know that one member can speak for the entire board. So, I mean, you could certainly pose.
Either you reviewed it or you didn't. Either it was part of the, part of what was presented to the board for their deliberation in executive session. This was a screw up. There was a major problem, and you had to go into executive session to resolve it, and you looked at only one side of the argument, is what I'm hearing. The October 1st letter was part of the record. It's on the website. My letter is not on the website because you say it came in too late, even though I called, even though I sent it to you, Mr. Ithal, I sent it to Mr. Dominguez, and I asked that the board be able to review the letter. Did you withhold that letter from the board?
Mr. Cradiville, I don't know as I sit here today whether that letter was actually distributed or not. I believe Mr. Dominguez when he said that it wasn't given because it missed a cutoff. However, I'd like an opportunity to look into that. And as for the deliberations that you're indicating that took place in executive session, I want to be clear. Executive session is not there are no deliberations that take place. The executive session in this case was because of a threatened or pending litigation, in this case, a threatened litigation. So it was
I have not threatened litigation, sir. And I'll ask you to review your own email to me on October 8th, where you say your letter and attachments were dispatched after business hours and were not seen by me prior to the planning board and were not part of the record at Monday's meeting. So I don't think you need to go back and check your facts. I think you already have acknowledged that you failed to share my letter with the board before they went into executive session to review the matter. And I think that's wrong. I think that's very similar and fits a similar pattern to what happened with the other problem that you had at the last meeting where you only heard one side of the case and then the other guy said, I'd like to make my case. And you said, you missed your chance. Screw you. Go home. This is really, really atrocious. And the people in New Brunswick deserve better.
Yeah, I think you've refreshed my memory a little bit. Yeah, your letter did in fact get in the next day for me because I didn't check my email. It was after 5 o'clock at some point that I think the letter was dispatched. So in terms of your dispatching a letter for consideration from the board, I would rely on Mr. Dominguez as to when that letter was received by him and whether there was an opportunity to dispatch it. But the opportunity to forward the letters to the board members, I think that if you had dispatched it during business hours, certainly would have been greater than if you dispatched it after business hours. But that notwithstanding, Mr. Cradiville, I didn't see your letter, I recall now, until the next morning.
So Mr. Dominguez didn't tell you that I had sent a letter? I specifically asked him to. I mean, you just weren't made aware of the letter?
I think I've answered your question, and I believe the chair had indicated that your time was up, or someone did.
Okay, well, I'll need email addresses for the board so that I can share the letter with them directly since you've withheld it from their consideration.
Thank you, Mr. Cradiville.
What's your email address?
I believe that you'd have to go through Mr. Dominguez to do that.
That's correct.
That's exactly what I did. I sent it to Mr. Dominguez and I called multiple times. Why wasn't the board privy to my letter? Why wasn't my letter shared? You shared the letter.
Mr. Cradiville,
the Friday before.
That question, I can certainly look into it more, but I think I've offered you an explanation, which was that I didn't receive that letter until the next morning because that letter was dispatched after business hours on the day of the meeting.
And it was sent to the secretary of the board. The secretary of the board had it, but it was not shared with the board. This is unacceptable. You need to get another executive session and you need to review all the information. You can't do this based on a partial record. You're really
Mr.
not being fair.
I understand. What we will do is look into it, and we will get back to you as to what happened once we have a better understanding.
Thank you, sir. I'll look forward to that.
All right. At this point, can I get a motion to adjourn?
It's Chris Steltel. I'll make a motion to adjourn.
Second.
Thank you, Chris. All right, everyone.
Good night.
Good night.